Hi, everyone. We're going to go ahead and get started. My name is Shayjuti Hossain. I'm the president of the Duke Muslim Law Students Association, and I'd like to start with the Muslim greeting of Salam, which means peace. Thank you all for coming tonight for this really important and timely conversation. We truly appreciate your presence and participation. First, I'd like to thank our sponsors, the Duke Bar Association, the law firm Baker Botts, and the Center for Law, Race, and Politics here at Duke. I hope all of you were able to get a panelist biography sheet. I'm not going to introduce all the speakers for the sake of time, but please go ahead and look at that to get an idea of the background of our speakers. Now I'll pass the mic on to Professor Huckerby, who will be moderating our panel tonight.
Thank you, Shayjuti. So my name is Jane Huckerby. I'm the director of the International Human Rights Clinic here at the law school. And I would like to welcome you on behalf of the law school to tonight's event entitled Counteracting Islamophobia, Rights, Policy and Next Steps. Before I introduce our panel and talk about the format for our discussion tonight, let me make a few brief and preliminary remarks about the context of Islamophobia in the current moment. To say that the challenges of Islamophobia are acute at the moment would be a gross understatement. We have witnessed an election cycle in which those standing for office countenanced various measures to target Muslims, including surveillance and closure of mosques, a ban on the entrance of all Muslims into America, and a database to track Muslims within the United States. For example, in March of last year, Donald Trump said, frankly, look, we're having problems with the Muslims, and we're having problems with Muslims coming into this country. Additionally, there has been much talk of a Muslim registry. That talk has been very short on details, but it appears to be a shorthand for requirements to have immigrants from Muslim-majority countries register with immigration authorities, a program that is very reminiscent of one that was initiated by George W. Bush called NSEERS, that targeted individuals from Muslim-majority countries and from North Korea, a program that was eventually scrapped. This week, in the administration's first week, we have seen 3 new executive orders on immigration. 2 of these were adopted on Tuesday, January 25. One concerned was entitled Enhancing Public Safety in the Interior of the United States, and essentially pertained to the removal of undocumented persons. The second was entitled Enhancing Public Safety in the Interior of the United States, pertained to the wall, the building of the wall. The third, signed late this afternoon, is an executive order that is entitled Protecting the Nation from Terrorist Attacks by Foreign Nationals. Now, we haven't seen yet a formal copy, a finalized copy of that executive order, but we know from the draft unofficial copy that it has essentially, that draft had 3 core components. The first of which was seeking to suspend the refugee resettlement program in the United States for 120 days. Secondly, indefinitely suspending the admission of Syrian refugees. And thirdly, suspending entry by non-citizens from 7 Muslim Arab majority countries, those being Iraq, Iran, Libya, Syria, Yemen, Sudan, and Somalia for at least 30 days. It should be stated that even though that draft unofficial copy focused on regulating immigration based on the nationality of individuals, as opposed to a ban on those from a particular religion, it has very much been treated by human rights advocates and immigration advocates as a distinction without a difference. In other words, the focus on countries is a proxy for the Muslim ban that was talked about during the election cycle. It should also be noted that this week also saw the leak of a draft of another executive order, which has not yet been adopted, entitled Detention and Interrogation of Enemy Combatants. That draft of that executive order, among many other things, employs the terminology of the fight against radical Islamism. Many will recall those were terms that the previous administration refused to utilize and have now found their way into a draft order. That particular order also seeks the policy review and recommendations on reviving the CIA's secret detention and interrogation program. Despite these quite rapid and very serious developments, it would, however, be wrong to think that Islamophobia is either new or limited to political figures and their nominees for various government positions. Hate crimes against Muslims by private citizens have been on the rise, emboldened by the changed political environment and an environment which seems to sanction fear and violence on the basis of religion. And indeed, and as I have mentioned, this is unfortunately not new. While the scale may be different and the magnitude as we go forward may be different, for at least the past 15 years, communities and human rights advocates in the United States have been pushing back against both government-led and private citizen-led violence, harassment, profiling on the grounds of religion or on the grounds of ethnicity as a proxy for religion. Against that backdrop in the current environment, there are ongoing efforts to develop the documentation of such crimes, to look at the legal and political challenges and opportunities for challenging Islamophobia, and really to ensure the human rights of all persons, regardless of their religion, nationality, ethnicity, and gender. As with any effort, at any time, anywhere, to address hate and to address violence and to address human rights, it requires the mobilization of multiple stakeholders working through multiple frameworks, whether that be law, politics, fact-finding, reporting, and documentation. And to that end, this panel is a timely and important opportunity to really talk about those different strategies and what the opportunities are in relation to each, how they relate to each other, and the challenges in pursuing these efforts. To that end, it is my great pleasure to introduce the panel. As Shruti mentioned, their bios are extensive and available to you already around the room, so I won't be repeating that, but we'll be handing over to, first of all, to Professor Darryl Miller, who is a professor here at the law school, to open with some remarks. Following the presentation of each panelist, we'll take a moderated Q&A, and so I encourage you to hold on to the questions that you will inevitably have for that moment of discussion. We will be leaving appropriate time to do so. Also to note that we are recording the panel, but we are not recording the Q&A. So please, feel free to ask the questions in which you want to during that process. And so without much more, I will now hand over to Professor Miller. Thank you.
Thank you. Can everyone hear me okay? I've got a little bit of a cold, so my voice might be giving out. So you have to excuse me if I interrupt my remarks by coughing or sneezing or doing something of the sort. So I think I would echo what Professor Huckerby has said. I think it's fair to say that certainly in my lifetime, I have not seen so nakedly and on display with not even an ounce of shame or embarrassment, the kind of appeals to bigotry and ethno-nationalism that we've seen in the past election. Nor have I seen such a reaction by the political our political leaders in their unwillingness to stand up and say anything in opposition to this incredible appeal to the very worst of our instincts. And I say that having grown up in Indiana, which was not the most enlightened part of the United States growing up. In just the last few days, President Trump has suggested that Chicago law enforcement needs to be less politically correct in the way they enforce the law, suggesting that he thinks that compliance with constitutional obligations of law enforcement is just some kind of lefty sentiment as opposed to a constitutional command. He's reiterated his belief that waterboarding and other forms of torture are an effective means of extracting information, even though it would be a violation of both the United States Constitution, the laws of the United States, and international law. As Professor Huckabee has described, the recent bans on refugees and immigration, seemingly with this sort of broad brush, that simply because you come from a certain area, you couldn't possibly have a legitimate claim to need asylum in the United States, no matter your age, no matter your gender. I think I keep coming back to a remark by Lyle Leibowitz that a friend had sent me, who said this about his grandfather in 1930s Vienna. And Leibowitz says this: he's going to treat, quote, treat every poisoned word as a promise. Treat every poisoned word as a promise. Don't normalize, don't assume it's bluster. Assume that it's going to happen. So that's the dark sense that we're in right now. But I also have some hope, because I think it's fair to say, as a teacher of civil rights litigation, that we've seen this show before. And the tools that are available to fight Islamophobia, to fight bigotry, to fight discrimination are far more entrenched and far more available in 2016 than they were for the nearly 150 years that African Americans have been subjected to bigotry in the United States and longer. So let me talk a little bit about these legal resources. I've been asked to talk a little bit about, for example, hate crimes legislation, as well as private litigation for violation of civil rights. I'm sure that will gender a lot more questions, but we'll take those up at the end. So as Professor Huckabee has remarked, there was a spike in hate crimes after the election. The genie had been let out of the bottle. People felt empowered to do things based on, again, their sort of worst instincts. That might happen, but it doesn't make it any less wrong or any less a crime. So on the federal side, there are a number of bias crimes in the U.S. Code, including the James Byrd and Matthew Shepard Hate Crimes Prevention Act, and I'll go through a few of them. But in terms of the general points I want to make about these statutes, they usually require some sort of specific intent. That is, just because somebody happens to be an African American or a Muslim or a Latino and is harmed doesn't necessarily mean there's a federal criminal violation. It has to be a specific aim to interfere or deprive the victim of a protected right or a specific motive to harm someone based on their religion or their ethnicity or their race. So let me talk about a few of these. 18 USC, AUSC stands for U.S. Code for those of you that are not lawyers. Section 241, it's a crime for two or more persons to conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of a right or privilege secured to him by the Constitution or laws of the United States. By the way, many of the statutes that I'm going to describe here, like I said, we've been on this merry-go-round before, were actually enacted in the wake of the Civil War to protect freedmen who had just been freed from bondage with the 13th Amendment and the abolition of slavery. 18 U.S.C. Section 241 applies to any person and is generally understood to apply to whether the person is a citizen or not. The effort to injure or oppress someone, doesn't have to be a knowledge of the victim in particular, as long as the act is used to threaten or intimidate such person. And unlike some of the other hate crimes or bias crime legislation that I'll talk about, there is no requirement that the U.S. Attorney receive a certification from the Attorney General that such a prosecution take place. 18 U.S.C. Section 245, it's a crime by force or threat of force to willfully injure, intimidate, or interfere with, or attempt to injure or intimidate or interfere with, and then it has a list of civil and social rights, including things like going to a restaurant, riding on a bus, voting, serving on a jury. This does require an Attorney General certification that such prosecution is in the public interest. 18 U.S.C. Section 247 makes it a crime to intentionally deface, damage, or destroy any religious real property because of the religious character of that property, or to intentionally obstruct by force or threat of force any person in the enjoyment of the person's free exercise of religious beliefs or attempts to do so. This does require the U.S. Attorney General certification and has been used in the past to prosecute persons for defacing or attempting to burn not only churches but mosques, and was one of the main charges against Dylan Roof for killing the African-American churchgoers in South Carolina. 18 U.S.C. Section 249, that is the Matthew Shepard James Byrd Hate Crimes Prevention Act. It makes it a crime to willfully cause bodily injury to any person because of the actual or perceived religion, national origin, gender, sexual orientation, gender identity, or disability of the person. The focus is on these injurious crimes that are based on the hatred of a person's actual or perceived religion. So as long as the motivation was because somebody thought somebody was Muslim, thought they were from Syria, thought they were Latino, that can be a crime. That does require an Attorney General certification as well. There is a state ethnic bias law. It is not nearly as strong in terms of the potential criminal penalties, but North Carolina General Statute 1440114, if a person shall, because of race, color, religion, nationality, or country of origin, assault another person or damage or deface the property of another person or threaten to do such act, shall be guilty of a Class 1 misdemeanor. So those are the kinds of crimes that the federal government and to some extent the state government can use to protect persons who are Muslim or perceived to be Muslim from bias crimes in the United States. So what about private rights of action? I mean, what I've just described, of course, requires the involvement of a willing prosecutor who is willing to deploy resources to fight bias crimes. They will be at the direction of the U.S. Attorney, who might have other priorities, and certainly the Attorney General of the United States, who might have other priorities. What kind of private rights of action are there? Well, the class that I'm teaching right now, and I think I see some of my students here, is 42 U.S.C. Section 1983. This is the basic statute that permits lawsuits against government officials for depriving persons of any right secured by the Constitution or laws of the United States. You know, all the lawsuits that are filed against police departments or police or municipalities because of deprivations of constitutional rights, that Section 1983, which, as my students will tell you, again comes from Reconstruction in an effort to protect freedmen, usually from the acts of either the Klan or the Klan in coordination with local law enforcement. 42 U.S.C. Section 1985. This applies to government agents or private parties. It is a civil version of the criminal statute that makes it a person liable for two or more persons to conspire to deprive someone of equal protection of the laws, and has been used, for example, to challenge denial of permits for persons that want to build, for example, a mosque, if the denial of those permits were based on some anti-Muslim animus. Currently, there is litigation right now, and I think before the Supreme Court of the United States, having to do with detentions of individuals, Muslim men after 9/11. Those are also being pursued against a sort of parallel provision that comes straight from the Constitution, which is called a Bivens action. Again, those are private remedies that persons who are harmed can bring a private cause of action. Title II of the Civil Rights Act of 1964 that prohibits discrimination in any place of public accommodation on the basis of religion and national origin, as well as sex and race. But since this is a panel in particular on Islamophobia, I'm going to focus on religion and national origin. Public accommodation has a fairly broad sweep: theaters, restaurants, coffee houses. All these places are obliged not to discriminate on against a person based on their religion or national origin. Title VII of the Civil Rights Act of 1964 prohibits discrimination by employers where the discrimination is a motivating factor if it's on the basis of religion and national origin, again, including race, sex, and so forth. That requires a filing. There's an exhaustion requirement. You have to first file a complaint with the Equal Employment Opportunity Commission. If they do not resolve the case, then you get what's known as a right to sue letter, and then you can bring your own action. Recently, in 2015, in the Equal Opportunity Commission versus Abercrombie and Fitch, a woman who had been denied employment on the basis of wearing a headscarf at an Abercrombie and Fitch store was able to pursue her case against the store on the basis that it violated her rights under Title VII. So that's about a little bit about the private rights of action. We can talk about them during the Q&A. I do want to mention a little bit about the sort of looming issue about the Muslim registry, because the issue with the Muslim registry runs straight into one of the what's known as sort of the anti-canon, one of the sort of cases that has never been overturned but has been repudiated in all but name, and that's a case called Korematsu versus United States. So in Korematsu, the president, acting through the military after the Pearl Harbor attacks and during World War II, issued an order that was implemented by the military requiring Japanese citizens in the West for no other reason than that they were Japanese to be sent to relocation centers. Fred Korematsu decided to stay in his residence rather than leave. In a 6-3 decision, the court upheld the conviction and said that the president during times of war has an extraordinary amount of power, even as against United States citizens. It is generally seen as having been repudiated, if not actually overruled by the Supreme Court of the United States. There has been all kinds of professions by political actors of every stripe that this is a black mark on the court, that this is a decision that is worthy of as much opprobrium as the Dred Scott decision. That all said, it has not been overruled, and for those of you that are big consumers of cable news, some people have been sort of floating the idea that you could do a Muslim registry against even United States citizens on the authority of Korematsu. Whether we'll see that, bridge being crossed again is something that I'm going to predict that when the President of the United States says there's going to be a Muslim registry, that we should be prepared to fight it if that's what it's going to be. Now, there are arguments that, this is no longer good law, that in fact World War II and an express declaration of war by the Congress is a different kettle of fish than what we have today, which is basically a delegation to the president to prosecute the war on terror. But that is something that looms out there. So that's what the law can do, right? And I'll just finish with this, right? The law is out there to act as a protection. What the law cannot do, and has never been able to do, is protect you from the little indignities, right, that go along with being a minority in America. The sense that you are a suspect, the sense that this isn't quite your nation, that other people don't treat you as 100% American, that you are an alien in your own country. And what do you do about that? Well, there's no litigation that can fix that. But what you can do is get involved. If you're a citizen, vote. Work on campaigns. Get involved. Support people that are going to repudiate this dark hour that we seem to be in, and never accept this as being normal. Thank you.
Thank you, Professor Miller. We now have Durham City Council member Gillian Johnson.
Thank you, and thank you everyone for inviting me to be here tonight, and for joining us here. I'm going to speak a little bit about what I see as the role of elected officials in this particular political moment, and also about work that has been done in Durham so far to express solidarity and support for Muslim communities in our city, and ending with kind of an open question, which I hope we can address in Q&A, is what can we do going forward? How can we move our city from the symbolic to taking more concerted action? So I believe that the role of elected officials right now should be to model resistance and insist on the value of an inclusive community. I spoke earlier this afternoon at a rally at the CCB Plaza, which was held by a refugee resettlement agency called Church World Service in response to Donald Trump's pending and now signed executive orders regarding immigration from Muslim countries. There were about 300 people who attended this rally, a number of whom were refugees themselves who spoke about their experiences living in refugee camps, mostly in Africa, being moved from camp to camp, from country to country for periods of many years, being separated from family, from their partners, from their children, and how this new political moment here in the US, most of them were recently arrived, that it has everyone extremely frightened and really worried about the very real possibility of being separated from their families for very long periods of time. We then learned that Donald Trump had actually signed this order this afternoon, which several people have pointed out is on Holocaust Remembrance Day, which brings up this really bitter irony that the United States during World War II also refused to admit Jewish refugees from Europe for precisely the same reason that we are now claiming we cannot admit refugees from Syria, that Nazi sympathizers would infiltrate the refugee populations and then use their position here in the US to launch attacks on us. So, as Professor Miller said, this is not new. We've been here before, and we know the result of this sort of callous disregard for human life. And so I'm hoping that as an elected official and as a member of this community, that I can model a strong and moral resistance to this sort of bigotry, and allow space within our city government for a real opposition to what's happening right now in our country. The Durham City Council has passed several resolutions in the last few years dealing directly with Islamophobia. In October of 2015, we passed a resolution supporting the settlement of Syrian refugees here in Durham. This was in response to a national conversation about stopping Syrians from entering the country, which was unfortunately jumped onto by then Governor Pat McCrory. And he said that he would support a move to ban Syrian refugees. And so our response was to pass a resolution unanimously supporting the resettlement of Syrian refugees here in Durham. And we received an enormous positive feedback for that action. Lots of phone calls and emails from people who appreciated our show of solidarity. Then about a year later, so that was in October of 2015, in November of last year, we passed a resolution condemning hate speech, racism, and Islamophobia. And we had, at the meeting where we passed this resolution, we were visited by a really exciting and interesting immigrant Muslim man who gave one of the best speeches I've ever heard at City Council, just really talking about his own experience and really showing us the value of this symbolism. I come from an organizing and activist background, and so I feel like I often don't feel that these symbolic actions are that significant. I would rather, do something that feels more actionable. But people have consistently come to us and told us that they do feel that Durham is behind them, that they feel more safe in this community, and that the value of these actions by the city is very strong in the community. After the election of Donald Trump, my colleague Charlie Reese wrote a letter on behalf of the council, an open letter to the community, reaffirming that we believe that an inclusive community is our strength, that we will continue to support and protect our communities in any way that is in our power. And we also received a lot of feedback for that action. Since that time, as it's become more clear what Donald Trump intends to do, and that he does intend, many people were saying before he was elected that they thought he would tone it down, or that they thought he would somehow be stymied by the actual, office of the presidency, and we can now see that that's absolutely not what's happened, that he does completely intend to move forward with such unjust laws as the executive order that he signed today, or a ban on Muslims, or a Muslim registry. In September of 2016, also 3 members of the city council, myself, Charlie Reese, and Steve Schul, signed on to a national letter that was circulated by an organization called Local Progress, which is a national network of progressive local elected officials. And over 500 local elected officials signed on to this letter in a national campaign against Islamophobia, which was also in direct response to the rhetoric of the Trump administration. So we've done, we've taken a number of symbolic actions, which is, primarily what is in our power to do. We are greatly constrained by the laws of the state of North Carolina, which, since y'all are all lawyers, I'm sure you know what Dillon's rules means. That because we are Dillon's rules state, we are not allowed to do anything, to take any action that is not directly authorized by the General Assembly. So in other states, the system is that you can't do anything that's not prohibited. In our state, we have to be explicitly allowed. So there are a number of actions that we would like to take, both on these issues and on other issues, that we are not, that we do not have the legal authority to do. And so that's been tricky in figuring out, how is our role what is our role as elected officials in this moment? What can we really do to protect people in our community? We're now finding a lot of people very concerned with the idea of sanctuary, with sanctuary cities, and whether Durham can provide sanctuary. Because of our state law situation, we would be in violation of both federal and state laws in seeking to be explicitly a sanctuary city. And so that is, more of a hurdle to cross with other folks on council than I think states who are only dealing with federal law and have state law on their side. Additionally, in October of 2015, the North Carolina General Assembly passed HB 318, which explicitly I think before we were still prohibited by Dillon's rules, but HB 318 explicitly prevents any city in North Carolina from forbidding their law enforcement to cooperate with immigration enforcement. However, there's no mandate for cooperation. We just can't have a mandate against it. So there is not a state law that forces us to send our police officers out and collaborate with immigration in any way. The city is going to be releasing a press statement, which I hope is good, in the near future to deal with some of the concerns that are coming up in the community around sanctuary. But I was very inspired by a recent speech that I saw online by the mayor of Boston and the city council members in Boston, stating very strongly that they will do whatever is in their power to protect their residents against this administration. And I hope that Durham can, to the best of our ability, follow in their example. So I think the biggest question for me and for everyone in this moment is, what can we do going forward? How can our local government actually concretely support local communities? And I think setting the tone is important. I think it's important that we have council people who are willing to, go to marches and go to demonstrations and really stand in solidarity with refugees, that every single resolution that I've mentioned tonight passed unanimously, every single council member is in support of these initiatives. I think it's also important that we model good governance, and we are seeing an extraordinary amount of terrible governance right now. So to be accessible and open, to be transparent and responsive to community concerns, and to provide, to show people that government isn't all bad. And I think that right now we just have such terrible examples, both on the state and national level, that we see people really losing faith in our institutions. And so being an institution that people can trust and can rely on feels important to me. I also think that it's important that the city directly challenge these unjust laws, either through the courts or through direct action. And a number of, we have several lawyers on staff with the city who I'm sure are going to be figuring out whether and how we can be involved in litigation as we move forward on issues that, that directly impact and hurt our people and our ability to protect our people here in Durham. And I also wanted to mention briefly how communities can and should seek help from the city. We've had a couple of incidents of hate crimes since the election. We had a graffiti incident downtown, and we also had a graffiti incident in a city parking garage. We are very, very quick to respond to these things. So if anything like that happens, immediately contact the city. All of our email addresses and phone numbers are online, and we also have a Durham One Call system, which is a number that you can call to reach the city administration at any time. And if any other things, any other issues come up, we are very happy and excited, and we really need to hear from community about what we can do for you and what you need, and what how the city of Durham can support you through this political moment. So please get in touch with us. Any sort of direct issue, call, write. We are very excited about working with everyone in Durham to really value and honor and move forward with an inclusive community, and keep our people together during this time. I think that we're in a place where we're seeing a lot of exploitation of division. And I think what we want to do is make sure that we're setting the tone and setting a model for a city that values the contribution of every human being, that every resident of our city is welcome here, that refugees are welcome here, and that we model those principles in practice. And I'd love to hear from anyone during the Q&A about what we can actually do, because I think we're all sort of struggling with that right now. Thank you so much.
Thank you very much. Our final panelist is Hamza Butler, who's creator of Project Marla.
How y'all doing? So I'm going to start with a quick prayer that I usually do before I give a talk. I'll say it in Arabic and then I'll give the translation. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. My Lord, relieve my mind and ease my task for me, and remove the impediment from my speech so that they may comprehend what I am saying. So tonight, I'll be discussing, as was mentioned, Project Mola, and more broadly how it fits into anti-Islamophobia activism. But I think before that, it's imperative that to say that to accurately talk about Islamophobia is to first talk about the history of white supremacy, and to effectively combat it is to start from the furthest margins and to resist transdimensionally. And that is to say that our activism, or more specifically our anti-Islamophobia activism, should be centered around helping the most marginalized and not the more privileged of us within marginalized communities. So to understand that our identities can intersect when we deal with issues of Islamophobia, we also may deal with issues of gender, of class, of language, of citizenship status. So Project MOLA is essentially a web-based application. Up on the slide here is just one of the pages for the Info Hub. But essentially it's a web-based application that allows users to report incidents of anti-Muslim violence. It's particular in many ways, but before we get into that, I want to discuss the tradition of community-based reporting that has informed this project. For me particularly, it comes from my experience as a Black person in the US and the Black liberatory tradition of community reporting. Of particular import is the legacy of Ida B. Wells. Starting, I think, 1890s, after her paper sort of started, it went downhill, she began reporting on the lynchings of Black men. And she said in one of her writings that those who commit the murders write the reports, and hence these blots upon the honor of a nation cause but a faint ripple on the outside world. They arouse no great indignation and call forth no adequate demand for justice. Her tradition, while it began in the Black press, it devolved more into a personal attempt to not only document, but to highlight that while there may be other institutions that document it, their interests weren't the interests of the most marginalized. And if you look more broadly at the history of the Black press and like the first paper, the Freedom Journal, I believe, one of their big points, the two founders, was that they wished to plead their cause. They too often found that mainstream media, where essentially things are reported, it skewed the reality of the discrimination that they were facing. So this was about returning to community and creating alternatives to existing platforms that could better express the reality of anti-Blackness. For tonight's case, of course, we're going to be talking specifically about anti-Muslim violence. And aside from the press and research that was done, there was also the oral tradition of just sharing experiences. And it just ties back to the reality that anti-Black violence that came and stemmed from white supremacy created, or not created, forced Black Americans, it forced women, it forced queer people to create their own alternatives. And in many ways, that's what Project MOLA is. So more specifically, Project MOLA is a web-based application created by members of the Chapel Hill Muslim community in response to the murders of Dia, Yusuf, and Razan. It typically serves as a counterpoint to the systemically supported notion that Islamophobia neither exists nor affects the livelihood of American Muslims and those racially, ethnically, and/or religiously profiled as such. It is an act of resistance. Our primary objectives are many, but they're not limited to providing an accessible platform for reporting that allows users to not only report anti-Muslim incidents, but also retain such information. So on the report, that looks like filling out a form and then the user being able to download it so they can have it on file for themselves if they want to take some sort of legal action, or to like have it for in the case of like they want to go to the news or something like that. Secondly, allowing access to information that is both palpable and interactive, and speaks on the various topics related to the formation and reformation of Islamophobia. And lastly, documenting, analyzing the collected information so that communities may organize accordingly. We plan for the statistics and the analysis stored by MOLA to aid in filling the vast gap of unreported anti-Muslim victimizations, strengthen the collective consciousness of Muslim Americans, and to provide data for Muslims to organize appropriate safety measures. In the application's opening statement, it describes Project MOLA as a defensive measure taken in hopes of preserving community, faith, and difference. And the key word here is difference. And I'm saying this because part of what a lot of activists miss when they try to, or they attempt to contextualize Islamophobia, is that the reality that there's very real difference amongst Muslims. There are Black Muslims, there are queer Muslims, there are Muslim women. And when we don't contextualize that complexity, we come back to this place where we're still stereotyping, even if it's a good kind of stereotype. This idea of the model American Muslim. While it's not this flip side of like the terrorist bearded guy, it still fixes us within a framework that's incredibly limiting. And by erasing that difference, it erases our humanity. And that's where this idea of intersectionality comes in. It's a theory popularized and created by Kimberly Crenshaw. And a lot of people use it. It's become a buzzword. It's really lost its potency. But essentially, it was a framework of analysis. And in her original writing where she released the term, she used it to analyze a number of legal cases. One of particular was Moore v. Hughes Helicopter, in which a Black woman was suing this company for discrimination, but she was suing them as a Black female, as a Black woman. And the issue, the legal issue was that they were only going to pick one. She was either going to get damages, or she's only going to get compensation for the fact that she was discriminated against as a woman, or because she was discriminated as a Black person. They provided all these statistics and numbers, and it completely erased the fact that her discrimination was very specific to her, and that she was both Black and a woman. And that brings a question to, as we were talking about anti-discrimination law, we constantly hear this race, gender, or we hear this or this idea of breaking our identities into these fixed categories and not approaching the realities that we as humans are multiple things at once. And while we have cases of Islamophobia, there are also cases that are specific to Muslim women. So when they bring a harm to the court, are they no longer women? Are they just Muslim? And it's about shifting our frame of analysis to something different that embraces this difference. And the reality that violence can be compounded is central to answering the question, why create alternatives? And this initiative is about shifting our question from who harmed and how should we punish them to who was harmed and how should we remedy them. And it also ties into pushing back against the state by way of prison abolition and by way of discriminate policing from law enforcement. The reality that there's a long history of like police surveilling Muslim communities or Muslims being indefinitely detained is to act like those problems don't exist and to still engage with the legal system is not only, it's not critical, but it leaves people in a position where they can only retain partial liberation. And partial liberation isn't any sort of liberation. It's not, half a right is not a right. And I think that's vital. And what this site does, especially in the reporting component, is when we collect data understanding that factors of gender, factors of sexuality, factors of class, all play a particular role when conceptualizing within the framework of Islamophobia. So I just want to talk about one example of how this intersection can occur. I know many of you probably heard of the incident at Abu Ghraib, where the detainees were tortured. That was largely framed as an issue of Islamophobia, but what a lot of people failed to realize was that it was also a question of sexuality and how these men were abused. And because this wasn't framed in a way where these abuses were like pulling harms that were compounded or weren't involved with harms that were compounded, like the harm that they faced specifically by way of sexuality, and how these men were sexually abused was almost completely erased from the story. And it was just about, oh, it's they're treating them bad because they're Muslim, and not because they have this perceived idea of their femininity or of their masculinity. So going from that as just an example of how intersections can occur, one question I get is what differentiates Mola? And one of the big things is we utilize what is called open source technology. And this project is open source, and that is to say specifically that the coding that went into this, the design elements, everything is available open to the public. So we want to push this idea that there's always room for improvement. We want these to exist almost as silos in their respective communities so that like people could take the code, they may have a developer in the community, and they could set it up in their own database so people can report to that community, and that community leader has, or that community has their own rapport with its constituents, and it allows space for not only people to feel safe to report, but also for people to have more intimate knowledge of what's specifically happening in their community. And hopefully with time, as people like take the code and take the designs, it will better and turn into something that could be implemented more universally across the country. So moving forward, I really want to leave this Friday remembering that no experience of mistreatment is too small, nor any narrative of suffering unweighted. To engage critically with the world around us is our right, and to demand justice is of our prophetic tradition. As Muslims, our existence is and of itself an act of political defiance against the products of Islamophobia. And our choice to speak out is a defensive measure taken in hopes of preserving community, faith, and difference. From the margins we resist, we are brave, we are aware, we are Muslim, we are Mola. Thank you.